The conversation has been about insolvency and also the restructuring process. A lot of businesses now are faced with that decision to either restructure or be insolvent. At what point does the labor conversation come in when a company is restructuring to stay afloat and they have to necessarily lay off, people so that they can still stay in business, especially in such times of COVID-19?
Right, thank you very much. I think that the conversation, as I indicated previously, there is a legal dimension to the conversation and there's a moral dimension to the conversation. If we are looking at restructuring as in the actual meaning of restructuring, then we are looking at Section 65 of the Act 651 of 2003. That actually provides that when an organization contemplates restructuring, amalgamation, shutdown, or any form of exercise that would affect workers and labor, then the applicable law in the Act 651 is the redundancy clause.
I see.
Now, the question is that, can we safely say that what we are confronted with is a matter that falls under redundancy? That's a matter for, a wide consultation. And for me, it's important that we do a dispassionate discussion as to whether or not what we are currently confronted falls within the ambit of redundancy. If we are able to say so, then obviously we have to apply that clause. And that means that the Labor Department has to be notified 3 months before the exercise can be carried out, which is a requirement under the Act 651. Once that is done, then if there is a union in the company or enterprise for which the restructuring, the amalgamation, insolvency, or whichever the case may be, will now go and investigate to find out whether the reason that has been assigned is actually the reason which the enterprise or the employer is relying on to undertake that exercise. If clearance is offered, then what is going to happen is that the unions that represent the workforce will now engage in negotiations as regards the compensation package that must be advanced to the affected employees. In most cases, the collective agreement that are negotiated have those clauses inserted in them. So these are terms that does not require the court to imply or custom or the commercial usage to be invoked or by dint of a statute. So these are provisions that normally you will find them in the collective agreement. So the collective agreement then is invoked. So what happens is that then you're going to look at what is being the practice as far as the package is concerned. So I'm careful not to limit this conversation within that, because you may have...
in a situation where that's if a company is going through restructuring, all right?
Yes.
So then what does the law say about companies going through restructuring and what happens to their employees in that regard? So those who will lose their jobs.
That's what I'm saying, that the Section 65 provides the grounds, provides the requirement, what has to be done in order to be able to have the consent to be able to undertake the exercise of restructuring. Because restructuring can either be that there are technological improvement or changes that will require that maybe a department, for instance, can be asked that because we have introduced some equipment, your services are no more needed, so we have to lay you off. Or the company probably may be going through some financial difficulties for which they cannot continue to retain the employees. If you cannot retain the employees, you can't ask them to walk home. The law demands that you go through the processes to lay them off under the redundancy clause. So that is what the law says. That is the position of the law.
I see.
If it is the reason being assigned is restructuring, because we have to take the reason carefully. If you're not careful, you may be assigning a reason that may not be the reason that informs the decision of the business.
How about in case of insolvency?
Yeah, I mean, that is it. I mean, if it's insolvency, then it falls directly under Section 65.
Okay.
That if it's insolvency, because if you take, for instance, the banking sector, you quite remember that we had difficulties and they had to lay workers off. It was redundancy exercise that had to be carried out.
Yes.
The fact of the matter is that it was difficult to actually have the payment. So you discuss what is going to be the payment schedule, whether you're going to pay the employees in bulk, or you're going to stagger the payment. So all those conversations will surface or would come during the discussion towards the redundancy exercise. But what you want to look at is that if you are looking at what we currently know to be confronting us, then we are taking the subject to a different angle altogether.
Right.
Because the Section 8 of the same Act vests the powers to terminate the appointment of an employee in the employer. So an employer, by his rights, can't terminate the appointment of an employee. By in doing so, he must ensure that he satisfies Section 15 of the same Act that provides the grounds. So you can say that those are the grounds that have been provided that will occasion a frustration. For instance, if the two parties have agreed that at this period would want the contract to be ended, the law would give you that. For instance, if the employee passes on or passes away, the contract becomes, it's ended. You cannot proceed further with it. If there's a proven misconduct or sexual harassment or proven incompetent, these are the grounds that have been provided in Section 15, for which the employer can't exercise his right to terminate as long as these grounds suffice or comes up for discussion. Apart from that, if you want to lay off on the basis of any other reason, what we have currently in our law is Section 65. If he fails to comply with the provision of Section 65, then 64 provides the remedies for unfair termination. And that remedy gives you 3 strands. The first one is reinstatement, re-engagement, or pay compensation for wrongful termination. So yes, the law has made provision for what happens given, what would happen if the employer would want to undertake a redundancy exercise.
What I'm very interested in is putting this conversation in the context of what's happening now. Because you have stated the law as it is. And there's clearly a lacuna in the law that you have quoted addressing a peculiar case of a public health emergency like this. So because of the absence of a specific act or clause in the law, would you say that it would be very fair to apply the law as it is written in the letter?
You know, what we have to do now is that, like, some employers have attempted to rely on the doctrine of frustration, okay, or force majeure. The doctrine of frustration demands that where the employer or the parties are unable to perform events, that makes the performance of the contract difficult or impossible, okay? But that impossibility must be situated on the subject matter. So assuming that you are in the aviation industry, the main business for which you are there is the planes must go and come. As you speak now, is grounded.
Yes.
The employer can say that because the planes are grounded, there's no productivity, no performance, you're at home, I want to rely on the doctrine of frustration. But he cannot actually do that without going through the processes of notifying the employees for them to actually meet and have a discussion on the issue. Because if he decides to rely on the doctrine of frustration and the employee goes to court, the court may call the matter and say that, look, considering A, B, C, and D, we are saying that even though you rely on the doctrine of frustration has really not occurred, because it's only the court that is able to determine whether what has occurred borders on frustration or not. Now, the question you ask, and which I want to address quickly, is that, is there a lacuna? I don't think there's a lacuna.
Why?
I think that in each case, the law is quite flexible and provide that the parties to a contract can have a conversation as to what is happening in the plant, in the organization. So
all of this, in your view, can be solved if the employer has a conversation with the employee that this is what we are confronted with, and so these are my options? How about if the employee is not satisfied with it? Sometimes, there's some cases of unreasonable demands. So what can the employer do then? Because, yes, you mentioned the aviation sector, but there are other businesses that rely on the aviation sector, like hospitality, and others. So if the owners of such businesses are sending their employees home, they sit with them, have a conversation, as you are recommending, but yet there is no consensus, then what can the employer do?
So what you are saying, that if there is no consensus, then it means the employer cannot unilaterally take the decision, because whatever the situation is, there's a need for the parties to agree. That you cannot take it for granted. Because the contract that was signed is a contract that elevates both parties to an equal footing. So both of them are equal. The employer is not above the employee is not above the employer. The employee is rendering services, giving his labor, you are paying in return. So where there is no agreement, then it means that you cannot proceed to undertake the exercise you want to undertake. If you do that, the employee has the right under the law to go to the court to claim that his right has been violated, he's been wrongfully laid off, terminated, and the court would look into the matter.
Are you saying that the employer doesn't have any right at all in such an instance, so that, yes, I'm out of business due to COVID-19. I sit with my employees, I have a conversation with them, they don't seem to agree with me on some of the proposals I'm making to them, they can go to court and make their demands or their rights.
Yes.
What is the right of the employer then in a situation like this, when clearly I'm out of business, I cannot pay you, I sit with you, you don't want to agree? It could be a typical situation happening right now.
Yes. And I also want to indicate here that I
think we should look at it both ways.
No, yes, but you see,
not look at just the employee alone.
No, we are looking at it in both sides. But you see, this country is governed by law. Otherwise, anybody can get up and say, I am hungry, so I'm going on a shooting spree, or I'm going to do armed robbery. He comes to your house, give me your money. You don't have money, he shoots you, he's gone. We are governed by law, and the law requires that at any given point, the parties must agree. If you cannot agree, there are remedies under the law, okay? Right. So it's not as if the law, there are procedures that you have to respect, okay? Right. So if the employer decides that, okay, the employee is not actually agreeing with me, he can decide to do what he thinks, in his opinion, is right. But that does not also prevent the employee to seek redress under the law as far as he feels that his right has been violated. It is up to the court to make a determination in the matter, and that there are avalanche of cases for which we've had